The Honorable, the Speaker.
Almighty God, we give thanks to you, the Creator of the universe, and humbly beseech you to direct and prosper the deliberations of the members of this House here assembled for the advancement of your glory and the trust and welfare of the people of Trinidad and Tobago. Grant that peace and happiness, truth and justice may be established among us for all generations. Amen, amen, namaste.
Oath or affirmation, announcements by the Speaker.
Honorable members, Honorable Brigadier General Ansel Antoine, MP, member for Davide O'Meara, has requested leave of absence from today's sitting of the House. The leave which the member seeks is granted.
Bills brought from the Senate, petitions, papers.
Minister of Finance.
Thank you, Madam Speaker. I have the honor to lay on the table the following papers on the order paper and on the supplemental order paper. Papers 1 to 2. The report of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Siparia Regional Corporation for the years ended September 30, 2009 and 2010. The report of the Auditor General of the Republic of Trinidad and Tobago on the statement of receipts and payments of the Intellectual Property Office for the years January 1st, 2012 to December 31st, 2012, January 1st, 2013 to December 31st, 2013, January 1st, 2014 to December 31st, 2014, January 1st, 2015 to December 31st, 2015. That would have been papers 3 to 6. Paper 7, the report of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Airports Authority for the year ended December 31st, 2007. The annual audited financial statements of Development Finance Limited for the financial years ended December 31st, 2013 and 2014. The annual audited financial statements of Portfolio Credit Management Limited for the financial years ended December 31st, 2012, 2013, 2014, and 2015. The annual administrative report of Torah Service Limited for the year 2015. The annual administrative report of the First Citizens Bank Limited for the financial year ending September 30th, 2015. The annual report of the Trinidad and Tobago Stock Exchange Limited for the year ended December 31st, 2015. the report of the Central Bank of Trinidad and Tobago with respect to the progress of the proposals to restructure CLICO, British American, and CIB for the quarter ended March 31st, 2015. Should be 2016. The annual audited financial statements of Point Lisas Industrial Port Development Corporation for the financial year ended December 31st, 2015. The proceeds of crime prescribed forms amendment regulations 2015. Madam Speaker, I beg to move that papers 1 to 7 and 21 be referred to the Public Accounts Committee. Papers 8 to 13 and 22 be referred to the Public Accounts Enterprise Committee.
Honorable members, the question is that papers 1 to 7 and 21 be referred to the Public Accounts Committee and papers 8 to 13 and 22 be referred to the Public Accounts Enterprises Committee. All in favor say aye. Aye. Any against? The ayes have it. The Minister of Trade and Industry.
Madam Speaker, I have the honor to lay on the table the following paper. The Annual Administrative Report of the Export-Import Bank of Trinidad and Tobago, Limited, for the year ended December 31st, 2014.
The Minister of Community Development, Culture and the Arts.
Madam Speaker, I have the honor to lay on the table the following paper. The Annual Administrative Report of the Community Improvement Services Limited for the year 2014-2015.
The Minister of Agriculture, Land and Fisheries.
Madam Speaker, I have the honor to lay on the table the following paper. The Annual Administrative Report of the Zoological Society of Trinidad and Tobago for the fiscal year 2014.
The Prime Minister.
Madam Speaker, I have the honor to lay on the table the following papers. The Annual Administrative Report of the Ministry of Gender, Youth and Child Development for the period October 1st, 2014 to September 30th, 2015. Also, the ministerial response to the report of the Joint Select Committee on Human Rights, Diversity, the Environment and Sustainable Development on the examination of programs and services which provide support to victims of domestic violence.
Minister of Rural Development and Local Government.
Thank you, Madam Speaker. Madam Speaker, I have the honor to lay on the table the following papers. The ministerial response to the 21st report of the Joint Select Committee appointed to inquire into and report to Parliament on municipal corporations and service commissions, on a review of the administration and operations of the Siparia Regional Corporation. The ministerial response to the 20th report of the Joint Select Committee appointed to inquire into and report to Parliament on the municipal corporations and service commissions, on a review of the administration and operations of the Couva Taboquite Talparo Regional Corporation, and the ministerial response to the 19th report of the Joint Select Committee appointed to inquire and report to Parliament on municipal corporations and service commissions, on a review of the administration and operations of the Mayaro Rio Claro Regional Corporation. Thank you.
Minister of Public Utilities.
Madam Speaker, I have the honor to lay on the table the following paper. The ministerial response to the 23rd report of the Joint Select Committee of Parliament on Ministries, Group 2, appointed to inquire into and report to Parliament on the administration and operations of Telecommunications Services of Trinidad and Tobago Limited, TSTT. Thank you, Madam Speaker.
The Minister of Planning and Development.
Thank you very kindly, Madam Speaker. I have the honor to lay on the table the following paper. The Planning and Facilitation of Development Application Fees Regulations 2015.
Reports from committee. Deputies, Prime Minister's questions, urgent questions.
The member for Barataria, Sanwan.
Speaker, question number 1 to the Honourable Minister of Health. Could the Minister indicate whether the shortage of yellow fever international vaccination cards is having a negative impact on the travelling opportunities of the citizens of Trinidad and Tobago?
Thank you, Madam Speaker. To contextualize the answer, the last death in Trinidad and Tobago, human death due to yellow fever, was in 1974. The last case of human yellow fever was in 1979. From that time to now, Trinidad and Tobago has been accustomed processing 10 international immunization cards, mainly 10 cards per month, mainly because what is required by countries as part of their visa requirements. So that has been the capacity for decades, 10 cards per month. Because of the recent outbreak of yellow fever in Angola, more countries are requesting these international immunization cards from countries like Trinidad and Tobago, where according to WHO, yellow fever is endemic. It is endemic in Trinidad, not in the human population, but in the red howler monkey population. To cope with the increased demand, the Ministry of Health has ordered 40,000 new international immunization cards. As of today, 5,000 have been received. The balance will be received next week. In the interim, the Ministry of Health, through their county medical officers of health, in the absence of an international immunization card, are issuing letters of certification with the requisite stamp and authorizations, which are being accepted by the airlines and countries to which people are traveling. So the traveling public is not being adversely affected. However, I must state that what we do not wish to happen, what we would like to happen, is that for people, before they go and request the vaccine, to check and make sure they have their original local immunization card, which should be treated with the same respect as your passport and your birth paper. You need that local immunization card when you are a child to automatically get the international immunization card. I thank you very much.
Member for Barataria, Sanwan.
Thank you very much for that comprehensive answer. Minister of Health, I just would like you to give the undertaking that you will continue to lobby to the World Health Organization to remove Trinidad and Tobago off the yellow fever list, as we had started in the last administration.
Thank you, Madam Speaker. As stated, WHO categorizes countries according to whether yellow fever is endemic. Now, yellow fever is not endemic in the human population, mainly because Trinidad and Tobago, from the time of independence, has always had a very rigorous public health program. Typically, to confer herd immunity on a population, you need 80% of your population to be immunized against a particular virus. Trinidad and Tobago has gone beyond 80%, we're 95%, mainly due to the strict and comprehensive immunization program for newborns ages 0 to 1 month, and we immunize 95% of people. So we will continue to lobby with the WHO. But by way of further answer, Madam Speaker, before June 2016, WHO's protocols advise that you get a booster every 10 years. WHO is now saying that that initial dose, that initial vaccine you get at age 12 months now confers immunity for life. So there is no need for anyone to visit a health center to get a booster shot. But I urge the population, before you travel, to seek out that immunization card, which is in a back drawer, a safe, wherever. Thank you very much.
Member for Caroni East.
Honourable Minister, is it possible for you
Members,
to indicate, for those who have not had the original card and those who have not been vaccinated, where can the general public receive their vaccinations in case they have to travel and requiring it urgently?
Thank you.
Minister of Health.
Madam Speaker, we printed in today's newspaper a FAQ on yellow fever. And in that FAQ, it tells you where to go to get information. So the typical protocols exist. The CMOH's office, they will administer vaccines if they need to administer vaccines. The country has no shortage of vaccines. Let me make that abundantly clear. But I urge the public, before you request a vaccine, to check to make sure you have your card first. Because the country has, we ordered 46,000 doses of vaccines for the year. And we normally have 20,000 live births per year. So the priority of that 46,000 has to be, the first call has to be our babies. And then we have a buffer of 26,000. But out of abundance of caution, I have advised PAHO as of today to ship another 10,000 vaccines, which will come into the country in the fourth quarter of 2016, to boost the already 46,000 which we will have. So we'll have a total of 56,000 doses.
Member for Naparimo.
Thank you very much, Madam Speaker. The second question to the Honourable Prime Minister. What is the position of the government on the result of the British referendum to leave the European Union?
Madam Speaker, the people who took part in this activity of leaving the Union, they more than anybody else don't seem to know what the result is, because it's still a work in progress. So it is a little premature for the government of Trinidad and Tobago to pretend to understand what is going on and to have a definitive position. The outcome of that very significant and far-reaching development of a referendum in the United Kingdom is still the subject of very live activity. It's very unclear, even in Britain, what the British position is, and in Europe, what Europe's position is, and what Europe's position on Britain is. All of this is still unfolding. But most interestingly, the leaders of that unfortunate development are now, in fact, making the news within the proceeds, shying away from or being ceremoniously dumped as the full effects of British adventure is unfolding to the world. The position of Trinidad and Tobago on that is that Britain should stay in the Union. But that's too late.
Member for Naparimo.
Given that we have a position from the government of Barbados, the Foreign Minister of St. Kitts and Nevis has articulated that country's position, and the Foreign Minister of Guyana. Has our government examined possible scenarios so that as it evolves, we will not be caught flat-footed?
There's nothing to be caught flat-footed about. We are observing what is going on, and whether I don't know that the countries you mentioned have additional sources that we don't have. We're all watching the television and we are all amazed.
They still have relationships with Britain.
Continue.
Questions on notice, questions for oral answer.
Madam Speaker, there are 30 questions for answer today. We will be answering 29, and we're asking for a deferral on question number 168 to the Minister of Trade and Industry. With regard to the written answers, Madam Speaker, there are 5 written answers, and we have all ready. Thank you very much, Madam Speaker.
Member for Caroni East.
Madam Speaker, question number 132 to the Minister of Housing and Urban Development.
Minister of Housing and Urban Development.
Thank you, Madam Speaker. With respect to part A of the question, the total amount paid to date for the construction of the Port of Spain International Waterfront Centre is $2,564,590,625. With respect to part B, payments are made semi-annually in January and July of each year. With respect to part C, the total amount outstanding is $1,805,558,080. With respect to Part D, the final payment is due to be made in January of 2023.
Member for Carinese.
Yeah. So based on your figures, Honorable Minister, the approximate total cost for the waterfront project would it be $4.3 billion approximately?
Approximately, yes.
4.3 billion for the waterfront project. Thank you.
Yes, Madam Speaker.
Member for Carinese.
To the Honorable Minister of Housing and Urban Development, again, question number 133. Thank you.
Thank you again, Madam Speaker. With respect to Part A of the question, the total amount paid to date for the construction of the Government Campus Plaza is $681,112,200. With respect to Part B, the total amount outstanding to complete final payment is $3,182,593,381.
Member for Carinese.
Would it be possible to indicate whether there was a cost overrun on this project, and if so, by how much?
Minister of Housing and Urban Development.
Madam Speaker, I'm unable to give that information, but I'll be sure to provide it in writing.
Member for Carinese.
So, at the moment, Honorable Minister, the total cost of the waterfront project will be approximately $3.76 billion. 681 plus 3.182. That's 3.
Honorable Minister of Housing and Development.
Yes, Madam Speaker.
Okay, thank you.
Member for Princess Town.
Madam Speaker, question number 130 to the Minister of State in the Office of the Prime Minister.
Minister of State in the Office of the Prime Minister.
Thank you, Madam Speaker. The approved organization structure of the Children's Authority makes provision for 242 members of staff. As of April 30, 2016, the staff complement was 132. As such, there are 110 vacant positions. In response to Part B, under the previous administration, Cabinet, in May of 2013, approved the organization structure of the Children's Authority, but also noted that staff for the decentralized offices will only be recruited when these offices have been established. These offices have not been fully established. Thus far, only 3 decentralized offices have been established in the form of 2 assessment centers, one at the Eric Williams Medical Science Complex, and another interim office at the San Fernando General Hospital, and one other place of safety. The other offices to be established are 2 assessment centers, one at Chaguanas and one at Princestown. The South Administrative Office, which will be housed on the compound of the Manhamby Road Assessment Center and is under construction. The offices or assessment facilities at Sangre Grande and Tobago are either being processed for rental or is still under consideration as the additional places of safety. As such, all the positions at the Children's Authority cannot be filled in the absence of these established offices. Additionally, the authority has experienced a high level of staff turnover since it began its operations. This high turnover of human resource has to be examined and addressed by the authority. The authority is to review some of its approaches to achieving its mandate, and this review should be undertaken before a firm decision can be made regarding the existence of a possible staff shortage. The Office of the Prime Minister has had initial discussion with the Children's Authority on the alternative approaches to the regulatory framework contemplated for some services. The authority has agreed to consider these approaches, which may yield to the same results using less human resource and other resources.
Honorable Minister, with respect to the outstanding offices that you have identified, could you give us an idea of what are the timelines that you're looking at in terms of whether or not you're looking at construction or rental of other facilities?
Minister of State in the Office of the Prime Minister.
Thank you, Madam Speaker. Some of the facilities have been identified already, and it's a matter of outfitting. In terms of timeline, I cannot give you that at the moment, but I'll give it to you in writing.
Member for Caroni East.
Thank you, Madam Speaker. Question number 131 to the Minister of Works and Transport.
Minister of Works and Transport.
Thank you very warmly, Madam Speaker. Madam Speaker, the question as put by the member for Caroni East posits or is predicated upon a very long-held but erroneous foundation that in respect of the Trinidad Rapid Rail project, for which the conceptual framework was adumbrated on the 15th of December 2006 in this Honorable House by the then Minister of Works and Transport, that all that has been accomplished in that project was a feasibility study. That is wholly false, Madam Speaker. In fact, the Trinidad Rapid Rail project involved procurement and project setup, planning, conceptual design and preliminary engineering, detailed design, construction, pre-operational testing, and operations and maintenance. In April 2008, NIDCO entered into a contract with the Trinitrain Consortium, Bui Travaux Publics SA, Alstrom Transport SA, RATP Development SA, Alstrom Trinidad and Tobago Limited for the initial phases of the project. That is to say, for the planning, conceptual design, and preliminary engineering for the project, which involved inter alia data gathering, ridership studies, demand modeling and analysis, as well as an environmental impact analysis and preparation and delivery of preliminary designs. Madam Speaker, this Honorable House should thus note that the chosen work program was much more, in fact, far more than a mere feasibility study upon which this question is falsely posited. With respect to Part B, to the dates of payment for this work, this information is very voluminous and reflected in a document that I have in my possession. Too numerous, of course, to render details at this point. So I'll make this available to the member at first opportunity and, of course, to this Honorable House. In respect of Part C, the total amount outstanding as at April the 30th, 2016 is $2,112,207. This sum represents unsettled claims for White and Case, a law firm. Part D, payment of outstanding sums will be undertaken on the finalization of the subject claims. Madam Speaker, I thank you.
For Caroni East.
Madam Speaker, we have not had a response to Part A and B of the question, which asks the total amount. I am not privileged to read the question.
Keep quiet.
Yeah. Madam Speaker, I asked the total amount paid to date. The Minister has not given that. And the payment dates, he has not given that. He said he has it in a voluminous thing. But I asked this question for the House, and the House ought to be privileged
and
to
member,
answer, not me.
Member, the Minister also in his response said that the details will be made available to you in writing. Next question, please. Member for Caroni East, you have another supplementary question?
Yes, I'm asking a question, the total amount paid to date, Madam Speaker. Tell us how much.
Member, that question is repetitious. I'm not going to allow it. An answer has already been given.
Madam Speaker, with due respect.
May we have some order, please? Yes.
With due respect, it's a question that we ask for oral answer. The Minister is proposing that he will.
Member for Caroni East, do you have another supplemental question?
No, based on that.
Okay, Caroni East. Members on the member for Diego Martin West and Diego Martin Northeast, please silence. Thank you.
Thank you, Madam Speaker. Question number 134 to the Minister of Finance.
Minister of Finance.
You had to answer the question. You're afraid.
Answer to part A. The National Academy for Performing Arts, NAPA, consists of 2 academies located in North and South Trinidad. In 2006, the original contractual cost for the construction of the academies was renminbi 812 million and was funded from a concessional loan from the Export-Import Bank of China. In 2011, another concessional loan facility in the amount of renminbi 207 million was contracted from the Export-Import Bank for additional works on both academies. Part B. The amount expended to date is renminbi 1,019 million, which represents 100% of the proceeds of the 2 concessional loan facilities. The total amount paid to date with respect to the North Campus is renminbi 706,400,000, and for the South Campus, renminbi 312,600,000. Madam Speaker, local financing in the amount of TT 48,665,693 was expended on both academies for further rehabilitation works and was met via budgetary allocation. The allocation for these works to the North Campus was TT 33,420,344, and for the South Campus, TT $15,245,349. Part C. There is a grace period of 5 years for the repayment of both concessional loan facilities. Repayment of the renminbi 812 million facility commenced on September 21, 2011. To date, a total of renminbi 261,935,483 has been repaid on this facility. The current outstanding balance is renminbi 550,064,516. Repayment for the renminbi 207 million facility will commence on September 21, 2016. Part D. The 20-year 2% renminbi 812 million concessional loan facility will mature in 2026, and the 20-year 2% renminbi 207 million concessional loan facility will mature in 2031. The final payment on each facility will be on September 21st in the years of their respective maturities.
Member for Caroni East.
The Honorable Minister of Finance, you brought in the South Performing Arts. That question answers just the North or both the North and South?
Minister of Finance.
Madam Speaker, I answered the question as asked.
No, I didn't hear that, sorry. I didn't hear that, Madam Speaker.
Minister of Finance, could you repeat?
Thank you, Madam Speaker. Madam Speaker, the Napa project was a combined facility, North and South. I have disaggregated the figures for North and South. Question 134 asks about the North, and the next question will ask about the South. You have already received information on the North and the South, and I will also give the South in the next question.
Member for Caroni East.
So, if I am to fully understand the Honorable Minister of Finance, the original cost for Napa is 812 million plus 33 million in an additional fee, making it 845 around there. Yes, Mr. Minister of Finance, for Napa.
Member, the information with respect to the original contractual cost, the total amount paid, that information has already been given. So I'll allow you a supplemental question.
The supplemental question is that 835 million that he spoke about, 812 plus 33, does that include the South Performing Arts Center?
Minister of Finance.
Madam Speaker, I was crystal clear. The facility for Napa is a consolidated facility comprising both the North and the South. And in answering this question, I disaggregated the figures for both North and South, giving a complete answer to the many supplemental questions the member is asking, and even future ones he might want to ask.
Member for Caroni East.
Yes, Madam Speaker. So in total, Honorable Minister of Finance.
Excuse me. Excuse me.
Yeah, sorry.
With respect to that sucking of the tongue that I just heard, that stoops.
Who do that?
That is not behavior that is becoming of this house. The member who's done that, I would ask you please to restrain yourself, and such behavior is not going to be tolerated in this house. Member for Caroni East.
To the Honorable Minister of Finance.
I just do it openly.
Is the total cost of both Napa and Sapa 1.019 billion, or the 48 is added on to that 1.019 billion?
Minister of Finance.
Madam Speaker, as I said, I have already provided the answer to all those supplementals and all the possible future supplementals. But since the member keeps asking the same thing over and over, I will repeat, with your permission, the whole answer. The National Academy for the Performing Arts project consists of 2 academies located in North and South Trinidad. In 2006, the contractual cost for the construction of the 2 academies was renminbi 812 million, was funded from a concessional loan. In 2011, another concessional loan in the amount of renminbi 207 million was contracted for work on the 2 academies. The total amount for the 2 academies is 1,019 million renminbi. I said that 5 times.
Member for Caroni East, question 135.
That's the last supplemental.
Member for Caroni. Members, may I have order, please? Member for Caroni East, you have exhausted your supplementals. We are now on. I've called you because of question 135.
Question 135 to the Honorable Minister of Finance.
Minister of Finance.
Madam Speaker, since I've already answered this question, I will repeat what I said before. The amount paid with respect to the South Campus of the National Academy for Performing Arts is 312,600,000 renminbi. The original contractual cost, as I've already indicated, for the 2 academies was 1,019 million renminbi, of which, let me see if I could stave off any supplementals, of which for the South Campus the total was 312,600,000 renminbi. Again, with respect to the amount outstanding, the outstanding balance on the loan, because it's a total loan for the 2 facilities, is 550,064,516 renminbi. And with respect to the time frame, again, it's a total loan for the 2 facilities, for which there was an original loan of 802 renminbi in 2006, 812 renminbi million in 2006, and 207 million renminbi in 2011. And as I've said before, the 812 million renminbi facility will mature in 2026, and the 207 million renminbi facility will mature in 2031, and the final payment is on the 21st of September in those years. I hope I have staved off all possible supplementals. I thank you, Madam Speaker. Oh, no.
I don't know you talk about renminbi. Could you give us the conversion rate to a TT dollar? You anticipated that?
Member, I will take that as another question.
Yes, it is.
But he has his money in renminbi.
I knew you would come with
renminbi.
Member for Naparima.
Speaker, question 136 to the Minister of Public Administration and Communication.
Minister of Public Administration and Communication.
Thank you, Madam Speaker. Public consultations on the way forward were held in November 2015. The board also considered financial data. Madam Speaker, I'm being disturbed. The board also considered financial data which gave evidence that the companies trade significantly from their mandates under the previous administration. The GSL wage bill increased from $8.8 million in 2010 to $18 million in 2015. CMG, which was established as a commercial entity with the ultimate goal of financial profitability, came close to achieving that with a loss of just $58,249 in 2010. In the period 2010 to 2014, however, the company incurred losses of $3.3 million, $3.8 million, and $5.8 million, respectively. The Board of Directors of CNMG and GSL made 4 recommendations on the possible ways forward for the 2 companies. Soon after those recommendations were received, they forwarded the recommendations to the Cabinet Committee appointed on State Enterprises for its deliberation. The committee has since met with both companies and is in the process of making recommendations to the Cabinet for the ultimate way forward. Upon Cabinet's final determination of the matter, the government proposes to alert the national community. This government, as it moves to eliminate all vestiges of waste, corruption, and mismanagement, and as it moves to restore public trust with good governance, will ensure that any new recommendations on the way forward will not be a repeat of the past. A timeline for implementation will be announced as soon as the final decision on the way forward is taken. Thank you.
Member for Couva South.
Thank you very much, Madam Speaker.
We have 10 supplementals.
Question 145 to the Minister of Public Administration and Communication.
And Communication.
The number of vacancies in the permanent establishment of the public service as of February 29, 2016, as provided by the Service Commission's Department, was 13,575. It is important to note that 7,657 of these 13,575 vacant positions are positions with bodies. These are vacancies where officers hold either temporary or acting appointments. Therefore, there are persons performing in these vacant positions. 1,632 of the 13,575 vacant positions cannot be filled. These offices are either abolished, awaiting classification by the Chief Personnel Officer, suppressed, outdated, or there are no eligible applicants to fill these offices, or there are challenges in attracting persons to these offices. 5,322 of the 13,575 vacant positions are without bodies. These are the real vacancies where there are no persons holding temporary or acting appointments.
The number of vacant positions in the public service as at April 30th, 2016, based on information from ministries and departments, was 7,403. With respect to the permanent establishment, it is important to note that filling of vacant offices in the public service is an ongoing exercise at the Service Commissions Department. Following the last realignment of ministerial portfolios and the consequent adjustment to the structure of the public service, ministries and departments, the Service Commissions Department embarked on a project in 2016 to fill approximately 5,700 vacancies. The first phase is intended to fill those vacancies in the Ministry of Education, Ministry of National Security, including Fire and Prison Services and the Immigration Division, the Ministry of Health, the Ministry of Finance, including Inland Revenue Division, Customs and Excise Division, approximately 4,633 vacancies. These are the largest ministries in the public service, and they create a socio-economic impact on the wider society in terms of delivery of services to the public. Simultaneous with this exercise is the filling of approximately 1,063 offices in the manipulative grade across the public service. For example, cleaners, drivers, messengers, among others, together with regular filling of other vacant offices. This approach involves the reconciling of records between the Service Commissions Department and the targeted ministries, and the updating of records. This is currently in progress. The second phase of the project will target government departments, for example, Judiciary, Industrial Court, Elections and Boundaries Commission, among others. With respect to contract vacancies and contract on employment on the whole, the government in the first 3 months of this administration moved to establish a committee to review the existing policy arrangements for the management of contract employment in the public service.
Honorable Member, your speaking time is expired. Member for Couva South, question 147.
Thank you, Madam Speaker. Question 147 to the Minister of Sport and Youth Affairs.
Minister of Sport and Youth Affairs.
Thank you, Madam Speaker. The Sports Company of Trinidad and Tobago, which acts as the implementing arm for projects under the Ministry of Sport, has indicated that the handover process for the National Aquatic Center and the National Cycle Velodrome has commenced as follows. The National Aquatic Center will be handed over to the Sports Company of Trinidad and Tobago. The entire handing over exercise is expected to be completed before the end of July 2016, at which point Olympic qualifiers such as George Bovell, Jason Phillip, and others will have the opportunity to continue their preparations for the Rio Olympics at a world-class facility. At the National Cycling Velodrome, final checks are being carried out, and facility managers were thoroughly briefed by SCG Caribbean Limited, the firm responsible for the facility's construction. Stringent testing of all competition surfaces and equipment will also be part of this final stage in the project life cycle. In the first 3 months following the handover process, access will be limited to national level athletes and teams for training for competition preparation. The first public events are expected to take place in the last quarter of 2016. And at these, they will serve as test events where all facilities and amenities will be operating at full capacity. Thank you, Madam Speaker.
Thank you, Madam Speaker. Apparently, the Minister indicated that the facilities will be formally opened in the last quarter of...
Did he indicate that?
Members, questions cannot be asked without preamble. So
I am seeking clarification, Madam
So
Speaker.
could you ask the question, please?
And when will the facilities be formally opened so that the constituents of Couva South could benefit from the progressive work done by the last administration?
Thank you, Madam Speaker. And again, it's not just the constituents from Couva South, but the entire country of Trinidad and Tobago. And the region, and more so the world, as we want to invite the entire world to come and utilize these facilities. But the member for Couva South was my guest at the opening, and as I said before, yeah, that's what we're doing on this side, Madam Speaker. We invite everyone. He is the member of Parliament for that area, and we sent an invitation to him to the testing. And as I said in my answer, that the process has started with regards to the handover. The SCG, the company, is working with us to finalize it. The first actual event will be held in the last quarter in those two facilities. With the national governing bodies, we are working with them closely to ensure that we leave the stars to the astronomers. They are the people that are running the sport, and we work with them with regards to having a proper event. And again, he will be invited. Thank you, Madam Speaker.
Member for Barataria, someone.
Thank you, Madam Speaker. Madam Speaker, in keeping with the method that was used by the Minister of Finance a while ago, could I use the same method and ask the Minister of Health the question 148, 149, 150, 151, 152, please?
Member for Barataria,
Yes,
someone. Are you asking question 148?
No.
That's where we've reached. Question 148. Are you asking question 148? And I'd like some order, please. Question 148. That's where we've reached.
Madam Speaker, I'm asking the same method of approach as the Minister of Finance before.
This is question. This is not
question
answer.
148, the Minister of Health.
I thank you, Madam Speaker. The answer to question 148 alone is: the objectives of the Aids to Nursing initiative are: 1. To relieve registered nurses and enrolled nursing assistants of non-technical activities. 2. To enhance the human resource cadre of healthcare personnel. It is a 5-year program implemented in April 2012. The program is structured for intakes of 3 cohorts to a maximum of 250 persons, with each cohort having 3 11-month cycles. The tenure of cohort 1 ended in 2015. The tenure of cohort 2 ended in April 2016. There are currently 237 students in cohort 3, which is expected to end in July 2017.
Member for Barataria, someone.
Thank you, Madam Speaker. Would the Minister undertake this program, the Aids to Nursing, was a foundation program for nurses, and these Aids to nurses...
Member, could you ask the question,
yes,
please?
the question is going to be, would they be going on to become PCAs after the Aids to Nursing program?
Thank you, Madam Speaker. Madam Speaker, this program was initiated without any consultations with nursing personnel or the chiefs of staff. So what we are now doing is an assessment with all the stakeholders, which should have been done before, to determine the way forward, especially as they mesh or not mesh with the PCAs and the entire hierarchy of nursing and auxiliary nursing personnel, and that assessment is ongoing as we speak. And after that assessment is done, we will make a determination on the way forward. And I give the member that undertaking.
Member for Barataria, someone. Question number 149.
Minister of Health.
Thank you. The answer to question 149 is as follows. The nurse intern is a new category of nursing personnel created by the amendment of the Nurses and Midwives Registration Act, number 8 of 2014. The program targets nursing students who are awaiting enrollment access results, and even those who were unsuccessful at the nursing licensing examination from as early as 2008. The nurse intern program commenced on September 2nd, 2015 with an intake of 75 persons. Of the initial intake of 75 persons, 66 persons are currently in the program.
Member for Barataria Samuel, question 150.
Question number 150 to the Minister of Health. We going to save time?
Thank you again, Madam Speaker. The answer is as follows. Northwest Regional Health Authority, Maraval Health Center, Carenage Health Center, Pitti Valley Health Center, St. James Health Center, Woodbrook Health Center, San Juan Health Center, El Socorro Health Center. North Central Regional Health Authority, for time saving, Arima, Chaguanas, St. Joseph Enhanced, Aruca, La Joqueta, St. Helena Health Centers. Eastern Regional Health Authority, Sangre Grande, Valencia Outreach, Comuto Outreach, Corial Outreach, Manzanilla Outreach, Matura Outreach, Grand Riviere Outreach, Beach Outreach, Brothers Road Outreach, Guayari Outreach. Southwest Regional Health Authority, Cedras Health Center, Debe Health Center, Freeport Health Center, Faizabad Health Center, Indian Walk Health Center, La Brea Health Center, Marabella Health Center, Pinal Health Center, Pleasantville Health Center, St. Madeleine Health Center, Tabaquite Health Center. Answer to part B, yes, a doctor is available at each health center that opens after 4 p.m. and on weekends.
Member for Barataria Samuel.
Just a supplementary. Would the Minister consider, since these are the health centers that were opened by the People's Partnership as a result of refurbishment by the CPEP contractors, undertake to ask the Minister of Finance if he could pay the CPEP contractors for refurbishing these health centers?
Member, I would not allow that as a supplemental question. Member for Barataria Samuel, question 151.
Question 151, the Honourable Minister of Health.
Thank you, Madam Speaker. The question to 151 is as follows. The Ministry of Health established a committee comprising representatives from the Ministry's legal department, the Trinidad and Tobago Registered Nurses Association, and the Nursing Council of Trinidad and Tobago. The mandate of the committee is threefold. 1, to review the Nursing Personnel Regulations 1977 with a view to updating same generally and preparing draft amendment regulations in accordance with the recent amendments to the Nursing Personnel Act, Chapter 2953. 2, to prepare draft regulations prescribing the conditions under which persons may be registered as advanced practice nurses, and 3, to prepare draft regulations prescribing the qualifications and experience required and the scope of practice for the advanced practice nurses. In this respect, Madam Speaker, the committee commenced meetings on November 5th, 2015, and the first aspect of its mandate is approximately 80% completed and is expected to be finalized by the end of July 2016. Thereafter, Madam Speaker, the remaining objectives will be addressed. Thank you very much.
Honourable members, the time for questions has expired, and all questions that have not been answered today and for which the government has the answers will be circulated.
For leave to move the adjournment of the House on definite matters of urgent public importance. Statements by ministers.
The Prime Minister.
Madam Speaker, with your permission, I have a statement to read, and I would like to crave your indulgence for an extra minute or two so I can complete it in the clearest manner for the benefit of the House and the national community. So I crave your indulgence.
So, Prime Minister, am I to understand that you're asking for 12 minutes?
15.
You're asking for 15 minutes?
Yes, ma'am.
And I have to put that to the House. Is this the wish of the House?
Aye.
The ayes have it. You may proceed. 15 minutes.
Madam Speaker, I have been authorized by the Cabinet to make the following statement. By instrument dated the 17th day of November 2010, Sir Anthony Coleman was appointed the sole commissioner, and I quote, to inquire into the failure of CL Financial Limited, Colonial Life Insurance Company Trinidad Limited, Clico Investment Bank Limited, British American Insurance Company Trinidad Limited, Caribbean Money Market Brokers Limited, and the Hindu Credit Union Cooperative Society Limited, with a view to ascertaining why such events occurred and to make such findings, observations, and recommendations arising out of its deliberations as the Commission may deem appropriate, unquote. The hearings of the Commission were delivered in two parts, with the Hindu Credit Union, HCU, being separated from the hearings into CLF and Clico. The Commission heard evidence and submissions for 85 days over a period from June 2011 to May 2013. Following the completion of the hearings, the Commission issued summon letters to a number of individuals warning them that they might be the subject of adverse criticisms in the report and inviting responses to the proposed matters of criticism. Counsel to the Commission, instructed by the then Attorney General Anand Ramlogan, were Peter Carter, QC, Edwin Glasgow, QC, Marion Smith McGregor, QC, Gerald Ramdeen, Shankar Bidesi, the Director of Public Prosecution, also requested that, given the sensitive nature, as I might know add, the widespread public interest and anticipation in this Clico saga, and this report of the Coleman Commission, the DPP should give the matter his urgent attention. Having perused the report myself without going into any unsavory details here now, I can advise the population that it contains very serious allegations of criminal misconduct on the part of a handful of privileged individuals who were associated with the Clico CLF group of companies. Accordingly, these findings of the report must, of necessity, require the attention of law enforcement through the office of the DPP, and therefore, pending the receipt of the specific advice that has been requested of the DPP, it would be wholly irresponsible of this government to publish or provide copies of the report at this stage. It has been sent to the DPP, and we shall await the receipt of his guidance and advice. Of course, we recognize that this Commission of Inquiry was of great public interest, not least of all because the government of Trinidad and Tobago was required to intervene and bail out CLF Clico in 2009 to the tune of many billions of dollars. Whilst in the last 5-year administration, the management of Clico, CLF, and the associated companies was shrouded in secrecy by the UNC administration, this PNM government has no intention of operating in that manner. This government will operate in an open, transparent, and accountable manner, as it has been doing. And once the Minister of Finance has completed his ongoing audit, he will come to Parliament and tell the citizens of Trinidad and Tobago the exact amount of money expended by the government with respect to this bailout. This will include the costs incurred by lawyers, accountants, professionals, and all others. Furthermore, any and all disposal of assets from the group will be announced to the public in an open and transparent manner as well. There are a number of findings of the Commissioner Coleman that we believe can be shared at this stage without harm, and I'll do so as follows. It was found inter alia, a number of executives acted in conflict of interest situations. There was over-leveraging and unacceptable intercompany transactions that seriously negatively affected CLICO, CIB, and BAT. CLF paid high premium prices in acquiring various assets, thereby resulting in overall prices being more than originally anticipated. CLF's auditors expressed disquiet in the course of 2008 at the rapidity with which the group was acquiring new companies such as Green Island and Lascelles de Mercado, at the growth of intercompany balances, particularly the indebtedness of CLF to CLICO and CIB, as well as the limited ability of CLF management to operate a much enlarged group, and recommended that there be no further acquisitions until the group has consolidated its new holdings and paid down the unsecured part of its indebtedness to CLICO. That recommendation was ignored in as much as CLF management proceeded to go ahead in what can be described as a reckless manner. The underlying causes of the collapse of all the companies were the defective business model of the CLF group and the failure of senior management to act to change it and the methods of corporate governance in accordance with the requirements of the Central Bank of Trinidad and Tobago and the recommendations of their own external auditors. Those were the predominant causes of collapse, although there were other contributory causes. Neither taking a loan, Madam Speaker, I crave your indulgence to complete the other pages. I have 3 minutes left, but I'd like to know if I can complete the other pages. I'd like to ask the House.
Members of the House, do I have your concurrence to allow the Prime Minister to complete outside? You may continue. The ayes have it.
Thank you very much, Madam Speaker. Thank you very much, colleagues. Yes, those were the predominant causes of the collapse, although there were other contributory causes. Neither taking alone nor in combination would the contributory causes have destroyed these companies' ability to continue to trade had it not been for the 2 predominant causes to which I have just referred. The business model which ultimately crippled the entire CLF group involved as its central feature the deployment by CLF, either directly or through subsidiaries, of funds originating in monies deposited by external depositors, as well as by CLICO and BAT in CIB, and also funds originating in policy premium income and investment dividends belonging to CLICO and BAT for the purpose of making investments in equities and real estate, and latterly for the payment of operating expenses of CLF itself and other group companies. In essence, Madam Speaker, the insurance companies were treated as the means of funding the overpriced and sometimes cavalier and hugely speculative investments made by or directed by CLF. The fundamental defects of this business model were first that once funds had been transferred out of CLICO, CIB, and BAT and invested by CLF and or other group component companies in real estate and equities, those assets lost the key attribute of liquidity, which was essential to the safe conduct of the business of both CIB and the insurance companies CLICO and BAT. Consequently, those companies lost the ability to respond to the requirements of external policyholders and depositors for money payments as fast as they fell due. The second major cause of the collapse was the continuing failure of senior management to adopt and give effect to the requirements of CBTT, the central bank, and the recommendations of the external auditors. There was thus a continuing failure of senior management to deal adequately or at all with two of the fundamental weaknesses of the CLF business model, namely excessive related party transactions and the pervasive asset liability imbalance. The Commission found that if during the period from 2004 to 2008, CLICO, BAT, and CLF had made any real effort to act with urgency to rebalance the group's business model in accordance with the requirements of the central bank and treat with the recommendations of the external auditors, it is probable that the collapse would not have taken place. These are some of the salient findings of the Commission that provide an explanation for the failure of the CLF-CLICO group. It is noteworthy that there was no adverse finding and or comment whatsoever with respect to the Honorable Attorney General, Mr. Faris Al-Rawi, who had served very briefly on the board of CIB and who was not even called before the Commission. And I place that squarely on the record. As I mentioned before, a number of adverse findings of criminal misconduct of a kleptocratic nature were found and recommendations made which would be for the DPP to consider. I make no further comment with respect to these areas in the report. The Commissioner made a number of recommendations with respect to legislation and or legislative amendments that the government will study and consider adopting in short order. Two areas that Commissioner Coleman focused on are the insurance legislation and the Commission of Inquiries Act. The Minister of Finance has promised to lay, the Minister of Finance has promised and has kept the promise and has laid today in Parliament a new Insurance Act that was the product of the previous Parliament's work, including the work of joint select committees. The government hopes that this will be speedily passed and the result in much needed changes of the insurance industry will respond to one of the major recommendations of Commissioner Coleman. Another area identified by the Commissioner for Reform is with respect to the enforcement of evidential orders and the attendance of witnesses who are summoned to appear before a Commission of Inquiry. As it stands now, those who fail to appear before a Commission of Inquiry when summoned face a maximum penalty of $2,000, which is highly unpersuasive. The existing penalty hardly persuades anyone to cooperate with a national need for information which they might possess. I have instructed the Ministry of the Attorney General and Legal Affairs to study these recommendations and to advise the Cabinet on an appropriate way forward, and in particular, to consider how legislation may assist in ensuring attendance of witnesses and the provision of documents in a more pragmatic and effective manner than currently exists. As you would have gathered from my presentation this evening, Madam Speaker, commissions of inquiry are very expensive. They are probably necessary and cathartic, if only they can be executed in a reasonable time frame, and more importantly, if the inquiry results in people being held to account and lessons learned can be put to use for future benefit. Once again, we have had an inquiry which has been hugely expensive and time-consuming. It is my hope that its findings are quickly acted upon to the satisfaction of a long-suffering people who have borne the agony of what has got us here, and whose fervent hope is that this experience does not further contribute to the cynicism which is associated with these things, and this effort does not gather dust on some obscure shelf. Madam Speaker, I thank you.
Member for Siparia.
Thank you very much, Madam Speaker. Honourable Prime Minister, is it appropriate for the Honourable Attorney General to be the officer you have selected to look at the recommendations, notwithstanding that no adverse findings have been against him, yet he was a related party with respect to the matter?
Prime Minister.
Madam Speaker, I sought your approval twice to read a statement in the Parliament in front of the national community, because I wanted to read slowly so that everything I have said could be understood and digested. I mentioned the Attorney General because I wanted to forestall the mischief that has already begun. I said absolutely nothing in that statement about the Attorney General having anything to do about interfering with the statement.
And it's public record.
I spoke about receiving it, taking it to the Cabinet, sending it unsealed to the DPP, and we await the guidance of the Director of Public Prosecution.
Public record that I recuse.
Continue.
Personal explanation, introduction of bills. On the supplemental order paper, the Finance Number 2 Bill 2016, presented by the Minister of Finance.
Minister of Finance.
Thank you, Madam Speaker. In accordance with Standing Order 64, 1B, I beg to move that the next stage of the Finance Number 2 Bill 2016 be taken on Monday, July 4th, 2016.
Honorable members, the question is that the next stage of the Finance Number 2 Bill 2016 be taken on Monday, July 4th, 2016. All in favor say aye. Aye. Any against? The ayes have it.
The Insurance
Members,
Bill 2000.
Members, could we have order, please? Continue him.
The Insurance Bill 2016, presented by the Minister of Finance. The Gambling, Gaming and Betting Control Bill 2016, presented by the Minister of Finance. Motions relating to the business or sittings of the House and moved by a minister. Public business, government business, bills, second reading.
Honorable members, the debate on the second reading of the following bill, which was adjourned on Friday, June 17, 2016, will be resumed. A bill entitled, An Act to Amend the Bail Amendment Act 2008, the Miscellaneous Provisions Bail and Kidnapping Act 2011, the Anti-Gang Act 2011, the Bail Amendment Act 2011, the Bail Amendment Act 2014, and the Bail Amendment Act 2015. The Attorney General, and I'm to advise that you have 16 minutes left to contribute to your...
Much obliged, ma'am. Madam Speaker, in 16 minutes, I crave your indulgence to continue my contribution. Madam Speaker, it is a matter of record now in the public that upon the urgings of the opposition, we suspended the sitting of and second reading of this bill, and in fact met with the opposition. But I'd like to clarify very quickly the process of engagement and consultation. On the 2nd of June 2016 specifically, I wrote to the Leader of the Opposition, the DPP, the Chief Justice, Law Association, Criminal Bar Association, and the Commissioner of Prisons, asking for commentary and cautioning that this bill would be dealt with to seek an extension of time in relation to the suspension, the setting of the law. That being the case, it wasn't until June 17th that the opposition engaged in any meaningful positioning, and in fact, if I'm not mistaken, it was the 28th of June that we finally met with the opposition. Attending on the opposition's behalf were the following persons: the Honourable Leader of Government Business, of the Chief Whip of the Opposition, Karen E. West, Chaguanas West, the Honourable Member for Oropouche East, the Honourable Member for Pointe-a-Pierre, the Honourable Member for Couva North, the Honourable Member for Naparima, and 2 senators, one Senator Sturge and Acting Senator Ramdeen. Specifically for the government, in attendance were the Honourable Leader of Government Business, the Member for Laventille West, the Member for Port-au-Spain South, and the Member for Toco Sangre Grande. Madam Speaker, at that meeting, where there was a cordial exchange of positions, there was specifically the request by the opposition for information. The government pointed out that with the inclusion of Senator Ramdeen on the team, that the opposition would have in its possession affidavit evidence from the Commissioner of Police and supplemental affidavit evidence from the Commissioner of Police, which provided a dearth of information in ongoing litigation brought by Senator Ramdeen and Mr. Anand Ram Logan against the state, seeking to have the declaration of unconstitutionality pinned in relation to the bail amendments. Now, I say that because the opposition would therefore have had in its possession a massive amount of statistical information available to it by no less a person than the Commissioner of Police. Madam Speaker, in the couple of minutes left before us, I am now obliged to speak to 2 important issues. One would be law actually is, and 2, what is necessary to avoid an absurdity in terms of what the Constitution says we ought to oblige ourselves in considering. Let me put it this way. It is abundantly clear by this bill that we seek to infringe upon Section 4 and Section 5 rights of the Constitution. We seek to specifically use Section 13 of the Constitution by inviting a 3/5 majority support in the Houses of Parliament, and we invoke in aid of proportionality, the argument of constitutionality, the fact that the rights of the citizen must be weighed in the context of the provisions of the law which we have now, and must be considered specifically in a society such as Trinidad and Tobago, where there is a scourge of criminality. We say that the intrusion must be viewed in the specific socio-macro economic and political considerations, recognized most recently as being valid considerations by no less an authority than the Privy Council in the recently produced judgment of the Privy Council on the 28th of June 2016 in the CLICO policyholders matter, and also in the Northern Construction case where the Privy Council spoke equally to that effect. The Honourable Minister of National Security will no doubt speak to detailed statistics which would be read into the reasonableness and proportionality of this, as will other members of the government bench speak to that. It is important, bearing in mind that we hinge the argument of proportionality upon the need to have a fighting chance to analyze the law and to look to its efficiency, specifically because the last government did no such analysis. It falls to this government to do the work. It is a matter of public record right now that we began consultations in the public domain in relation to the prisons in particular. And permit me to put on record this fact. In the prisons, we have 2,345 persons in pre-trial detention. Of that, 1,019 persons, or 43.4%, are not eligible for bail because they're there for murder charges. 1,326 people, being 56.54% of the total number, are eligible for bail. I've put that number specifically because if the law is allowed to have a sunset go to effect, we must look to the impact upon the judiciary of Trinidad and Tobago as to how 1,326 persons will be processed in the criminal justice system. That takes me right now and immediately to what the law is. I want honorable members to understand what we are dealing with today is not the Anti-Gang Act only. We are specifically looking at the state of the amendments of the Bail Act, being 11 amendments of the Bail Act from the period 1994 to 2015. And specifically, if the sun is allowed to set on the bail amendments, we are going to revert the law to 1994 as only amended by a small amendment in 2005 where we changed shall to may. We are going to rewind the laws of Trinidad and Tobago 22 years into the past if the law is allowed to have a sunset operationalized. And I put that squarely because successive governments have amended the provisions of the Bail Act to take care of advances in criminality. Both PNM governments and UNC governments have specifically said, give the law a fighting chance, give the criminals a run for their money and a challenge by taking avail of consideration of how our society must treat with this. That means, if the law sets, Madam Speaker, we are going to specifically throw away anything to deal with kidnapping for ransom, anything to deal with heinous crimes to children under the Children's Act 2012. We are specifically going to throw away trafficking in narcotics, possession of firearms, all of that goes. This, Madam Speaker, is cause for concern. And therefore, in the few minutes I have ahead of me, my task now is to tell you what the state of the law is. In 1994, the original law which came into effect basically saw a 3 strikes law in 10 years. If you had a charge, you applied for bail, and you had 3 convictions in 10 years, you were denied bail. In 2005, by Act number 19 of 2005, we fettered the word shall into may and gave the judiciary a discretion to exercise its powers in a more amplified sense as the 1994 Act allowed. Act number 32 of 2005 was the beginning of 2 strikes and 15 years. If you came for a charge, you wanted bail, and you had 2 convictions recorded in the last 15 years, you would not be permitted to access bail in the strict sense of the word, and the court would be invited to consider certain limitations. Act number 30 of 2006 saw a provision where the sunset clause put in 2005, which was for 1 year, was amended to be extended for a further 15 months. In 2007, Act number 10 of 2007 came. We saw specifically the amendment of the schedules to the 1994 legislation, and we split the schedules so that you had specified offenses and violent crimes. 2007, we saw 2 pieces of law with a UNC in opposition. You saw the UNC hold the PNM government to sunset clauses of 3-month extension and then 1-month extension. Specifically in 2008, there was a significant amendment which came in by the introduction of law which catered to the changes in criminality, armed robbery with violence, possession and use of a firearm for intent to endanger life. There was a movement to accept where criminality was coming to. In 2011, the government changed. We saw a UNC government come into power, and specifically, we had the bail amendments alongside the Anti-Kidnapping Act. And very importantly, we saw the genesis of a 1-strike rule. In 2011, there were amendments to the Bail Act so that we could actually extend the time frame from which someone was bound to be barred the right to approach a judge. We moved from 60 days to 120 days. In 2011, we put in with unanimous support, full PNM opposition support, sunset clause for 5 years. Specifically, we saw 2 strike plus 15 years have an addition on of 1 strike and 10 years limitation. And I'm being succinct as I can with the limited time. But Madam Speaker, in 2014, there was a significant amendment by Act number 1 of 2014, where we saw the whole introduction of a removed law where there was a reversal of burden of proof upon the accused to show why he should be set free, moved by the then Attorney General Anand Ram Logan, and that moved safely into the 2015 positions where we went away from, as we come along the years, 3 strike, 2 strike, into 1 strike, where they said if you have a charge and you want to access bail, but you have another charge of certain matters, you can't access bail. And these amendments were all packaged specifically by a then UNC government saying, listen, criminality has the advantage on us, we must act with alacrity, and we must cause a society to accept that the Constitution must be used with a 3/5 majority to allow for an intrusion into Section 4 and Section 5 rights, where one is permitted the right to go forward for bail. Today, Madam Speaker, we have a very different position. We have a government saying, give the time to do the consideration that is required. Let us be put into a position to do the work that was not done by the last government. Let us do the work that the people require. Let us produce the statistics which will show whether kidnapping for ransom continues to work the way it did when SORT was around. Let us look to the efficiency of what the anti-gang law looks like. Let us look to the issues of bail. Let us complete that work and come back within a 2-year time frame to present statistical information to the population. Instead, we have an opposition that says, give us facts. When that opposition did approximately 5 amendments to the law, which were based upon cabinet notes presided over by the then Prime Minister, now leader of the opposition, which would have had all the particulars as to the rational and constitutional reasons to invite the Parliament to exercise a Section 13 exception to Section 4 and 5 rights. Today, we have a leader of an opposition having, if with her team, a lawyer who is able as an acting senator to provide all the information that is requested by the opposition in the form of affidavit evidence, which we had discussion over in our meetings held with the opposition. But today we are being invited to tell Trinidad and Tobago, kidnapping for ransom has been solved. Anti-gang has been solved. Firearm offenses has been solved. Don't worry about all the laws to protect you being considered and information being brought forward. Just let it fall. So I would like the constituents who were affected by crime and criminality and who supported the UNC in the last election to ask the opposition a serious question. Is it that kidnapping for ransom is no longer a problem? Is it that firearms and ammunition is not a problem? Is Couva North to be taken seriously in calling for greater measures of control to deal with lockdown of borders and ports, to deal with the position of guns and ammunition? Are we listening to Couva North, please? When the shoe was on the other foot, a PNM opposition gave support to a then government, now in opposition. That shoe is now in the opposition's possession. The shoes are on their feet. And we simply ask the opposition to tell Trinidad and Tobago what their position is in relation to this. And with those words, I beg to move, Madam Speaker.
Honourable members, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Bail Amendment Act 2008, the Miscellaneous Provisions Bail and Kidnapping Act 2011, the Anti-Gang Act 2011, the Bail Amendment Act 2011, the Bail Amendment Act 2014, and the Bail Amendment Act 2015 be now read a second time. Member for Siparia.
Thank you very much. Madam Speaker, I thank you. And I listened to the Honourable Attorney General today, and on the last occasion when he made his presentation on the legislation, the bill that is before the Parliament. And I thought that as we approach this debate today, that we should not engage, as far as we can, should not engage in a tit for tat and back and forward, and he said and she said and they said, and when you were there you said this, and when we were there we said that. I thought we would not do that. And in fact, I do not intend to go down that road. I intend to deal with the substance of the law and to look at the provisions that are before us. However, it is passing strange that the Honourable Attorney General would spend the few moments that he had today, 16 minutes, to really try to tap up and buff up the members of the opposition, instead of taking the time to not to beg, to provide, not for us, to provide for the public the reasons as to why we should support this bill and others should give support to it. And I want to quote from the Hansard, and I'll give you the date of this Hansard. So who is the bright brain who drafted this? It has to be somebody who knows absolutely nothing about what the existing law has in it. Who would have drafted this and get the government to come back to Parliament, to waste Parliament time, trying to make unbailable what is already unbailable. I am putting you on notice now that you're walking that same road, because I do not know who would have drafted this and caused you to be coming here to support it as something good. And we have said you all could not be serious. You could not be serious because, for a start, most of it does not make any sense. Secondly, we told you we are not supporting it, but you want to hammer us home.
Who say that?
We told you in private conversation we are not supporting this. This is nonsense. I read for you up front all the nonsensical components. So today I am saying to the government, do not waste our time. We will not be bullied into passing bad law. We will not be bullied into passing bad law. This was on the Hansard in the debate when the 2014 Bail Amendment Bill was debated, and the words coming out of the mouth of the then opposition leader, the member for Diego Martin. So the attitude then, the attitude now.
I don't believe that.
You'll need to give my time checker. Thank you. Yeah. Attitudes, Madam Speaker, in terms of how we go forward. The Honourable Attorney General on the last occasion spent quite some time about court cases and talking about court cases in relation to the existing provisions with respect to bail. And in those court cases, he made some comments really appearing to attack persons who had brought cases to deal with constitutionality and so on of the court cases. And it reminded me that these provisions that we're looking at is basically to take away jurisdiction from the courts and to place that jurisdiction really in the hands, in a sense, of a police officer, because there's a police officer who will arrest someone and charge and so on, and then there's no bail for the 120 days. So in addition to the deprivation of rights to liberty and so on, there is also in these provisions a deprivation of the right to access to a court, because for 120 days you do not have access to make that application for bail. And Madam Deputy Speaker, it is very clear in our constitutional framework, and I will not burden you, Madam, with that, very clear in our constitutional framework of the separation between the judiciary, legislature, and executive, and of course there's the overlapping of that. But you know, just today, I saw the value and the benefit of keeping the courts and keeping the judiciary as a sentinel guardian of the Constitution for the determination of rights and obligations. And two really landmark cases decided today, Madam Speaker, one in our own jurisdiction and one in the jurisdiction in Austria. And in Austria today, the courts there rule annulling the result of presidential elections because the rules had been broken, and they annulled that election. That was the presidential election annulled in Austria. In Trinidad and Tobago, the High Court today declared as unlawful, illegal, unjustifiable, and unreasonable the actions of the present cabinet in refusing to disclose the names of attorneys, both local and foreign, who provided advice to the government, the dates when they gave advice, and the fees paid to them with respect to removal of the governor of the central bank, Mr. Rambaran. The judge ordered the cabinet, led by Dr. Rowley and the Minister of Finance, Dr. Imbert, to produce the information within 18 days to the applicant. And I think this represents a victory to the people of Trinidad and also for the courts, with respect to the courts. And so I'm saying the importance of the judiciary, where there are tensions in the society between the executive in the political arena and outside of the political arena. It is the court that retains that guardianship of the rights and obligations of the citizenry. So today here we are, brought in one bill, the 2016 bill, the Miscellaneous Provisions, Anti-Gang and Bail Bill, 2016, where we are being asked to extend the operation of 6 acts, 6 pieces of legislation. The AG has enumerated those 6 pieces of legislation. And what these acts basically do is to prescribe circumstances in which bail shall not be granted. So the 6 pieces of legislation tell us, look, we must not grant bail in certain circumstances. And these are respect to offenses and so on. So we have the Bail Amendment Act 17 of 2008, which was already extended by Act 11 of 2011, and then for 5 years, so everything expires August 2016. We have Act number 9 of 2011, and this one, interestingly, I don't think the AG has clarified, I may have, but I don't recall. And this one, we are not indeed extending the law where there's a sunset clause. This one has no sunset clause whatsoever. Correct. And therefore, we are seeking in this sitting, or in this debate and consideration, to insert a sunset clause. Then we have Act 10 of 2011, the Anti-Gang Act, Bail Amendment Act 11, 2011, Bail Amendment Act 1 of 2014, and 7 of 2015. All we have been asked to extend until August 2018. Now, there are 2 things that jump out immediately on the face of this very short bill. It is a very, very short bill. I think the clauses, 10 clauses, very, very short, but far from simple, because we are dealing with very fundamental rights and abrogation of those very fundamental rights. But just on the face of the bill itself, what jumps out and gives us pause, what do you say, pause for a cause? What jumps us? Cause for a pause and pause for a cause, both. It gives us cause, yes, to pause. And of course, we pause for a cause, just jump in ex facie, off the face of these bills. 1, it needs a special majority vote. And secondly, that they are with respect to sunsets provisions, which are, of course, as we all know, temporary provisions coming to expire. Those 2 things, and if time permits, I will come back to the Section 13 matter, and of course, with respect to sunset provisions as a whole. And of course, it deals with restrictions on the right to bail. Now, I think we all know it is a cardinal principle in our law, from the common law through the Constitution, that the right, the presumption of innocence until proven guilty. And from the earliest times, in fact, if I may quote from the common law, which is now codified in our Constitution, in the case of Aaron Badger, which is an 1843 case, 7 JP 128 at page 130, Chief Justice Denman, in a case where sureties for bail were refused by the magistrate, stated, "The law is clear and is as old as the Statute of Westminster." Lord Coke, in his commentary upon that statute, says that to deny a man plevin who is plevisible and thereby to detain him in prison is a great offence and grievously to be punished. Blackstone, referring to the ancient statute, the habeas corpus, and the Bill of Rights, calls it an offence against the liberty of the subject. Madam Speaker, this right to bail and all the provisions not to deprive of liberty and so on are now enshrined and entrenched in our Constitution, Chapter 1, Part 1, Sections 4A, 5.1, 5.2, F1, 2, and 3. And again, I will not go into quoting those because of the time constraints. So I think we are clear, and that's why you need a special majority. But you see, that Section 13 tells us that you can pass the law with a special majority, but it doesn't stop at Section 13.1. 13.1 says, yes, a bill that abrogates, infringes, and so on, the fundamental rights in Section 4 and 5 will still have effect, but it must do certain things. One, it must express on its face that it is in need of this 3/5 majority, and it must be passed in the Houses of Parliament with a 3/5 majority. That's fine, so we are being asked to vote for it and to have the 3/5 majority. But that's 13.1. But we fail to understand that even if we give the 3/5 votes, there is another very important provision, which is 13.2 in the Constitution, that it must be reasonably shown to be, not to be reasonably justifiable in a society which has a proper respect for the rights and freedoms of the individual. That's 13.2. This section, the bill for which has been passed by both houses, final vote, each has been supported by the vote of not less than 3/5 all the members, 13.2, and 13.1, an act to which this section applies may expressly declare it shall have effect either inconsistent with 4 and 5, and if any such act does so declare, it shall have effect accordingly, unless the act is shown not to be reasonably justifiable in a society that has a proper respect for the rights and freedoms of the individual. So there is, the test is double. It's a double test that the legislation must pass. One is for us to give it a 3/5 special vote, which we can or cannot do or should not do. But the more important test will be reasonable justification. The Honourable Attorney General uses the word proportionality, and that in itself is a debate in the courts as to whether we look for a reasonable justification or we look for proportionality. And the very lengthy judgment of Chief Justice Archie, Justice Jamada in the case of Barry Francis, a very lengthy judgment. In fact, a very historic occasion arose when the Court of Appeal sat 5 judges of the Court of Appeal, a panel of 5. That doesn't normally happen. You have a panel of 3 Court of Appeal judges. 5 judges of the Court of Appeal sat in the case of Francis and the state of Trinidad and Tobago. This is reported at 2014 86 WIR at 418. And in this case, 5 judges of the Court of Appeal sat. And that was an area for full discussion of what is reasonably justifiable, what is proportionality, how should it play, and that I think is very important in how we look at the legislation we are being asked to approve today. So we had the Bail Act then, so the right at common law and in the Constitution that you're entitled to bail and so on. And then we had our Bail Act 1994. In its long title, it states it is an act to amend the law related to release from custody of accused persons in criminal proceedings. And then coming from about 2008, Act 17 of 2008, which is one that we are being asked to extended in 2011, and now we've been asked to further extend it, Act 17 of 2008, and coming through these other 5 pieces of legislation, restrictions on the right to bail, all of which, as I say, we're being asked to approve today. So that's where we are in the state of play with respect to bail in our country. And I mentioned the sunset clause. I don't know, just as a factoid that we may just mention in passant, that these sunset provisions have been used throughout legal history. And in fact originated, I'm told, I read, in the Roman times when they had to go and collect taxes And when they had to raise forces and troops to go and fight wars and so on, they had to move quickly, but they had it for a temporary time only to go out and raise the troops or go out and raise the taxes to do any emergency works and so on. But what is the purpose of this sunset clause that we have found now in all these 6 pieces of legislation? And the purpose, as I sort of hinted at before, was pause for a cause. The purpose of making it temporary is to give you an opportunity in a short space of time to review the legislation, to see how it has worked. Has it been effective? What have you learned from it? Should you change any, should you do away with it, let the sun set completely? Should you amend it in any way, add or take away from it? That's what a sunset provision gives you in a piece of legislation, that it remains temporary and can be reviewed and extended or not reviewed as the case may be. Now, I think the Honorable Attorney General tried to do a job on us in a sense. I would go there, but tried to really, in a sense, the Honorable Attorney General, you know, stated some numbers and so on. I don't know, in his last contribution on this same bill, when he talked about all the statistics and that he had taken a position to get a lot of statistics on all kinds of matters, you know, and I was wondering if the CSO had moved over to the Office of the Attorney General, Central Statistical Office. But he quoted all these statistics and will not give us the most important data. How many persons are in jail without bail under the provisions of these 6 pieces of legislation? How many persons? How many persons? And then the Honorable Attorney General tells us we should go and ask Ram Logan and Ramdeen. I don't know what he has with these fellas. I really don't know. Every time he speaks, you have to mention their names. Go ask them. But you know, from September 7, 2015, you are in charge. Take charge. Don't tell me to go and ask Ramdeen about some affidavit he filed in court and what statistics. You come here today and I say you don't want to talk to us, you may not wish to, that's okay. But the public wants to look, pick up the newspaper today, both editorials. They're saying you need to come here and explain and justify why you must have such serious breaches of rights. Both the Express, the News, both here today. And in the last several days, we've seen the Law Association, your good colleagues, your friends in law, you know, say they do not support it. And I must say they've been consistent. Because in 2015, they said they did not support it. And now, once again, they don't support it. I think several others, very learned and distinguished counsel, Mr. Martin Daly himself, also raised questions about these pieces of legislation. Yes, so there's pause. There's cause for pause. And today we have not had the kind of information we would like to see. So let's look at this issue of reasonable justification and proportionality. Yes? What is a test? And the test must be that your objective must be a legitimate one. And the AG knows those cases, the Freitas and Northern Construction, the whole raft of cases going down the line. And he knows it well because he has used that word, I think it's one of his favorite words, proportionality, from way back in opposition to now. Proportionality. And so the law is proportionality. The aim, you must have a legitimate aim. The measures that you use, the means that you use to interfere with your right, must have a rational connection with it. It must not avoid less, as you say, less stringent or severe measures. And of course, there must be a fair balance. And that's the test laid down in a raft of cases with respect to proportionality. And as I say, the whole issue of reasonable justification. Let's start off, first of all. Let us state very clearly today, and do not let us get carried away the numbers that were quoted by the Honorable Attorney General in prison have 2,000 plus people. No, they are not the ones that he could categorically tell us are in jail without bail because of this law. Do not for 1 minute get carried away and believe that persons presently in jail without bail, that they would be automatically freed. I read that in a newspaper. Look, if the sun sets on these pieces of legislation, wow, it's going to be chaos, it's going to be madness. The jails will open, people run up and fly out, frightening people. That will not happen, because what happens, should the sun set on these and they're not extended, what happens is that persons will be entitled to do what? To apply for bail. They will get the bail. The court now, it goes back into the hands of the court, that the court will now look at all the circumstances of the individual cases and in its discretion grant or withhold bail. This was the position before these pieces of legislation came into play, the 6 pieces that we are looking at to extend today. That was the position then, and indeed that was the position way back when, throughout. Look as long ago as in the case of Hines and our really famous case dealing with the separations of powers and so on in Jamaica, you know, that case was about criminality, that they had tried to set up a gun court in Hines and R because they were saying, oh God, too much crime, let's do something with these gunmen, let's do it. And the Privy Council was so clear, Lord de Pluck, when he said, listen, when you're looking at breaches of rights and so on, when you're looking at the separation of powers, what you're looking at is not the expediency or how good the law is, how convenient the law is. You know, that's not what you're concerned with. It must be in keeping with the supreme law of the land, the Constitution. And therefore, the law must be proportionate. The law must be reasonably justified. Is it? Yes, the aim, the objective is a nice one, it's a good one. All of us, and I know I'm very clear, all of us, we are all concerned with the criminality in the country. We all want to fight the crime, bring down the crime. The question remains, do these 6 pieces of legislation help us with that? And let's get to the statistics very quickly. The bit that we have that comes from CAPA, which is from the police branch. If you look at those statistics, first of all, you will see, for example, that the one crime that is increasing the most, yes? The one that is just flying out of the door, yeah, is murder. But Madam Speaker, from time immemorial, there has been no bail for the crime of murder or the offense or the charge of murder. And if these 6 pieces of legislation sunsets on them, you will still have no bail for a charge of murder. You will get no bail. So let us not fool ourselves that if the sun sets on these 6, hey, the murderers getting bail and running out the road to murder more. Not happening. It's not going to happen. So let's look at the statistics. Let's look at this. We look at the statistics for murder, and we will see what has happened from January to May 2015. There were 196 murders. From January to May 2016, there were 232 murders. January to May 2016. What changed, Madam Speaker? They came into government. The PNM came into government. From September to December 2015, 141 murders. So since they came into office, 372 murders. Madam Speaker, these people have no bail. The charges of murder, no bail, and yet the murders are increasing up and up and up. We look at the statistics again, and we will see. You need to give me a time again, time check. We will see, with respect to murders, there during the 2010 to 2015, that those numbers went down. Homicide numbers went down. We will see, for example, that the serious crimes went down to the lowest in 31 years. 31 years. There was a 49.75% decrease in serious crimes. Is it because of these 6 pieces of legislation? In the last 5 years, serious crimes went down by 49.7, almost 50%, by half. Is it because, and the detection was abysmal. It hasn't improved. It's gone even worse under your government. From 18% plus where we were, it has come down under your government to about 8%, about 8.6%. And so the serious crimes, I'm saying, have been reduced from when we took office in 2009 to the present time. So why did that happen? Is it because of these 6 pieces of legislation, Madam Speaker? No. No. It was not because of these 6 pieces of legislation. It was because we had a vision and a mission in a holistic framework that we did legislative, infrastructural, administrative, and my colleagues will come in the details with respect to those issues. The appendices, that's why I'm having trouble here. Here it is, appendix. It's a murder rate, and here is serious crimes. And here is crime stats and achievements. Here we go. Achievements. So legislative measures, Madam Speaker, in the period from 2020 to 2015, legislative efforts, we would have brought into Parliament, laid into Parliament and passed legislation. I believe it was like something like in our first session, 42 pieces of legislation we laid in this Parliament. How many has been laid in the last 10 months? In a week will be 10 months. Do we know? How many laid and how many passed? 9. 9 laid. How many passed? You want to really talk about that? Yeah. 9. In your first session, yes? We have 2 months going into recess, yes? When we come back, we go only until about, what, 17 September? The session will end. Do you really think that you're going to reach anywhere to the legislative framework that we did in that first session? No. We did, and my members, as I say, legislative efforts done. Assistance with respect to infrastructure. I think we built about 8 or 9 police stations, if I'm not mistaken. 10. The acquisition of naval vessels. Today I feel very proud to know that in every police vehicle, and we had promised that in 2010, that there you have the GPS in every police vehicle. And go because I don't have the time to say all the things here. The achievements 2010 to 2015.
And that is why serious
And that is why the serious crimes went. It was not one shot. It was not a standalone issue. It was not a standalone issue. It was a holistic network that we had. Madam Speaker, I really, whether you are dancing or I'm dancing or the other, what does it matter? It doesn't matter. It doesn't matter. Really, it doesn't make a difference. And so, Madam Speaker, there are issues right today, that we need to pay attention to. Right here in this Parliament, in Prime Minister's question time, we asked the Honourable, I asked the Honourable Prime Minister on this is 8 April 2016, right here. We asked the Honourable Prime Minister what steps were being taken to improve the detection rate and so on. The Honourable Prime Minister said, and I quote from the answer, what we are doing is ensuring that they have the training, the resources, and the high morale that is required to confront the criminal element. Very good. Then Dr. Munilal asked a supplemental question, and he said, Honourable Prime Minister, I note that Prime Minister's statement on the morale of the police service needs to be improved to deal with this matter. And so in this context, I asked him whether or not his government intends to put the mechanism in place to provide compensation, $1 million, to the families of officers who fell in the line of duty. And of course, the Honourable Prime Minister said the answer is yes. We will put in place proper procedures and so on. Fast forward to May 20th, 2016. We again asked the Honourable Prime Minister. And what did he tell us? 4 weeks, which would give Cabinet the we have. I would say by the end of June, this should be operationalized. Today is what day? Today is the 1st of July. And not a single family of officers who fell in the line of duty have been compensated. Not a single family. We talk about morale in the police service, it boosts the morale. The Honourable Minister of Finance promised by the end of June that police officers and so on would be paid their back pay. Today, tell us how many. My information is 45 to 50% of the 7,000 officers have received half of their back pay. 50% of the force have received 50% of their back pay at the end of June. Have not received the 50% they were supposed to get. Only 50% have received that. And we talk about building morale in the police service, Madam Speaker. And those are some of the areas that we definitely need to look at. And at the end of the day, when we look at all that has been done and said, with respect to the bail amendment bills and putting criminals behind bars and so on, I just want to understand. The Attorney General mentioned, I need to know how many minutes. The Attorney General told us there are cases. Which is? Okay. Told us that there were certain cases that had been filed in the court. And we would want to be very careful how we spoke here because of the case of Pepper and Hart, that the Hansard could end up in the court and so on, and that we wouldn't want to in any way impact those cases, and that they'd filed an appeal in one of the cases and so on. And what those cases are telling us is something very important. So on the one hand, we have to look at proportionality, we have to look at reasonable justification and so on.
Honourable Member for Siparia, your 30 minutes have expired. You are entitled to an additional 15 minutes if you intend to avail yourself of it. Member?
Thank you very much, Madam.
You may proceed.
Yeah. About cases pending in the court and being careful of what is said and what is done and so on. But when you read that, you see again the need for amendments to have been made to this legislation. Yes, sunset clause, not anything being done or said to us or to the nation, we need to make changes. And we needed to, because we saw the anti-gang law, for example. Big headlines, the fellows walked out of court. Yes? See the front page of the newspapers, people just walked out of court, charged under the anti-gang law and so on, and they walked out of court. Yes? Then we see the cases, Justice Kara Gobin, the case of Ryan Mahaber, in that case where it went to the point to say that the case was, it was absurd to see the wording that was in that particular piece of legislation, and yet we're being asked to put it back, to pass it, and to go ahead with it. And I'm saying that is something that the Honourable Attorney General, in his review over the last 9 to 10 months, could have taken a look at. And then we come to the whole issue of the process, and that, I think, is very important. This is not about whether you talk to me or did not talk to us, or talk to anybody here. It is the whole process of how we went about. And I need you to find, this one is 3, I need you to find 4. When you look at in 2010, when we came into office, the 2 pieces of legislation right now we've been asked to extend. Both acts is 2. I'm saying there are 2 I'm going to speak of. 2 in 2011, yes? There were 3, in fact, in 2011. 2 of them was the subject of a joint select committee who gave grave deliberations with respect to those 2 pieces of legislation. So it didn't just land on the Parliament's table. In fact, from when it was introduced in the Parliament in 2010, it took until the following year, 2011. So there was a long period of consideration, not just by the Parliament, but by others, yes. By others, Mr. Martineau and others who were involved. So let's take the first one. This is now Act number 9 of 2011, which we've been asked to extend. That was introduced in this House on the 20th of July 2010, but was not assented to and become law until the 19th of May 2011, almost 1 year thereafter. And why? Because of the consultations that were taking place through the Joint Select Committee, and I'm sure my colleagues will tell us a bit more about the long process of consultation before that became law. Further, we had Act 10 of 2011, which we're being asked to extend. That too was first introduced in the Parliament 16th of July 2010, but did not become law until 23rd May 2011, about 1 year later. Again, a long process of a Joint Select Committee, and the report is here, and I'm sure one of my colleagues will go through all the work that was done over the course of that year to come to a compromise and consensus on Act 10 of 2011. With respect of Act 11 of 2011, a third piece we've been asked to extend, again, late 16 July 2011, did not become law until 23rd May thereafter, about 1 year. The assent was on 23rd May. I'm sorry, madam, this one is 2011, so this was just for several months. That particular one went through. This was the Act 11 of 2011. One of 2014, we had, during the month of September, August 2013, Act 1 2014 became law, which we have been asked to extend. There were about 3 months of consultation, well reported in the media, between the then government and the opposition. Several meetings took place, highly covered in the media and so on, before we came to consensus on that particular piece of law, Act 1 of 2014. So I'm saying it is not simply about we met in the Parliament room and we agreed or did not agree. There was a long gestation period in order to arrive at a consensus of law that we think could have served our purpose at that time. So what is illegitimate? I'm talking as a process. What is the substance? And the substance in the judgment of Justice Gobin, in the case of Ryan Mahabir, that case is one that we should take cognizance of. And the AG is shouting across that it is under appeal. Fine, it's under appeal. You know, there is a committee between the courts and the Parliament. And I do not think any judge is going to be swayed, and I would hate to think any judge would be swayed by anything I said here or anything the Honourable Attorney General said. And that is why we have a separation of powers. So I cannot influence.
I would like to hear the contribution. Please continue. Please continue.
Thank you very much. So there's a case of Ryan Mahabir. The Honourable Attorney General mentioned the cases. There was no applause when he mentioned that. There's a case, another one, Sobers. There is another, this is a judgment that is in the public domain, madam. Madam Justice Gobin, she declared the conditions in the remand section of the prison was in breach and so on. In that case also, she spoke of, we want to remember this was a case brought by the Police Service Welfare, Social Welfare Association. And in the affidavit of Inspector Anand Ramisa, he said, the matter is of grave concern to the membership, since they are entitled to carry firearms. The automatic deprivation of bail in circumstances when allegation is made of the commission of a scheduled offence, while quite coincidentally an accused officer happens to be in possession of a licensed firearm, has caused disquiet, protest and objection. As a result, police officers have been demoralized, demotivated and worried that while they are performing their duties, even allegations maliciously made expose them to loss of liberty because they happen to be armed while on duty. The provision requires clarification, and the judge stated, I have found too, a plain reading of the section exposes what I consider to be an obvious draft in error. Left in its present form without amendment, the application of the literal meaning will continue to yield irrational results. This is a judgment that anybody could pick up and read. It's in the public domain. It's under appeal, certainly, but again, we pause for a cause with respect to that. So you have that, you have the other cases that the AG mentioned in his, when he first started speaking on this debate. And again, should we now rush in? Should we be rushing to extend these pieces of legislation? Given that we've had problems with the drafting of it, given there have been persons who have walked away free because of the legislation. Many in the public have called that should be amended, we should repeal that anti-gang law, and so on. No such move has been made, no such attempt has been made to really review the pieces of legislation. And so I come finally to where we are. And it is this. We cannot trust this government. And an example of that arose just a few minutes ago, right here in this parliament. Right here in this parliament, madam. I can go historically to point why we do not trust this government. I can go back and talk about Tim Gopi Singh, the member for Caroni East, paraded in handcuffs. Why?
True.
For a charge that was never a charge in law. But by then he was paraded all over Port of Spain in handcuffs, only for the court to come and say, hey, listen, there is no such offense known to law. Finbar Ganga, charge. It took 12 years. Now, if these pieces of laws were there, what would have happened? Jail with no bail. Jail with no bail. I do not trust this government. We saw what happened with the SSA law in this parliament, where the Honorable Attorney General had to tell the country we have no privacy rights.
No privacy.
Remember that? We do not trust this government. We saw the whistleblower legislation that the very CPC in the Ministry of the Attorney General says you can't do that. It is not reasonably justifiable. You cannot do it. And we do not trust this government. And so I say today I saw something happen. And I rose when the Honourable Prime Minister finished his statement. And to ask the question, is it appropriate to have the Attorney General as the officer to look at the recommendations? And the Prime Minister gave an answer that was not an answer. Maybe he didn't remember what he said. But we got the statement. And the statement says, I have instructed the Ministry of the Attorney General, Madam, and Legal Affairs to study these recommendations and to advise the Cabinet on an appropriate way forward. So who is the Ministry? The Attorney General is in charge of it. But the story goes further than that. Because the number two minister in the Ministry of the Attorney General.
Which one?
Members, please, I would like to hear the contribution for the member of Siparia. Her voice seems a bit strange, and I'd ask us all to cooperate.
Sorry about the noise. I appreciate your protection, madam. And then there is the number two lawyer in the Ministry of the Attorney General, the Honourable Minister Stuart Young. Minister Stuart Young also has some questions to answer. And so I am saying we cannot trust them. We cannot. Madam, I believe you are in charge of standing orders, you know?
No, excuse me, member for Siparia.
Yes, madam.
You're very experienced. Please rise above that and continue. There's been no issue addressed to me.
Thank you very much. You know, the Honourable Attorney General comes here to complain about Ramlin and Ram Logan and how they went to do cases and they were there in the government before and Sturgeon and so on. And you know, the Honourable Attorney General is a party to those proceedings. And if he had an objection, he could take that objection to court, but no, he knows he has no real objection. So he comes to the Parliament to cry. He comes here to cry about it. And so I'm saying, we cannot trust them. Here we are. The story is in the public domain that Minister Stuart Young also was involved in that commission of inquiry. And therefore, should you put this thing, is it appropriate, I ask again, to put the Ministry of the Attorney General, where both persons have been implicated, notwithstanding that no adverse finding has been made in the report. They are both involved in the matter. They were both involved. I take back the word implicated. I withdraw the word implicated, and they were both involved. Yes, implicated, but they were both involved in the matter.
The member has withdrawn the word, but the word. And I hope
I'm
the
sure-
Hansard has noted
I'm
that.
sure the record will show that the word implicated has been withdrawn by the member. Continue.
Both members have had involvement with the Clico matter. The Honourable Attorney General mentioned by the Prime Minister in the Clico Bank. And of course, Mr. Stuart Young Minister well knows his role in the Commission, Minister Stuart Young, Commission of Inquiry's report into Clico, was also involved in that matter. So here we go now. We want to fight crime. We are in the fight against crime. we are in the fight against crime, Honourable Madam, and this has been put forward as a legitimate weapon. We are not of that view. We come again to say that the government has no plan in the fight against crime. The 10-point plan that was so pontificated and broadcast and published everywhere. Police Complaints Authority, amend the legislation. Municipal police, parliamentary oversight, urban renewal, anti-gang legislation. Review the anti-gang legislation. How many years ago this was put out? I said the government has absolutely no plan to fight crime. This is the 10-point plan. And we will not and cannot in all conscience support the bill before this House.
Member for Port of Spain North, St. Anne's West.
Good afternoon,
intelligent debate.
Madam Speaker. It is indeed a pleasure and a privilege to rise to contribute to this debate here this afternoon. And I start off, Madam Speaker, through you, to set the stage for the public of Trinidad and Tobago to be provided this afternoon with the right facts and for them to know exactly what it is that is before this House today, despite the attempts, as usual, to misrepresent what is actually before the House today. Madam Speaker, what is before the House today is a bill which is entitled an Act to amend the Bail Amendment Act 2008, the Miscellaneous Provisions Bail and Kidnapping Act 2011, the Anti-Gang Act 2011, the Bail Amendment Act 2011, the Bail Amendment Act 2014, and the Bail Amendment Act 2015. Madam Speaker, what should immediately jump out to the right-thinking citizens of Trinidad and Tobago are the dates of these various parent pieces of legislation that we're seeking today to merely extend the time for. You have three acts passed in 2011 and one act passed in 2015, all of which fall under the domain of that dark period between 2010 and 2015 when those on the other side were in charge. Madam Speaker, with the greatest of respect, all that this bill is seeking to do here today, despite the usual attempts by those on the other side to invoke fear and fear-mongering, is extend the periods of time for pieces of legislation that they saw fit to bring Naparima, that they saw fit to bring to this House during their tenure and their period. All we're doing is seeking to extend the time for those various pieces of legislation to August 2018 to do the work that should have been done during the period that they brought it initially. The Miscellaneous Provisions Anti-Gang and Bail Bill 2016 seeks to amend the sunset clauses in the following pieces of legislation: the Bail Amendment Act 2008, the Miscellaneous Provisions Bail and Kidnapping Act 2011. And I pause there. Is it that those on the other side, Madam Speaker, are telling the population of Trinidad and Tobago that the serious crimes which these pieces of legislation were originally brought to affect the rights to bail and to apply for bail for have disappeared? Yeah. Is that what they're saying? So once again, they're telling the law enforcement agencies of Trinidad and Tobago, don't worry, because we in the opposition are of the view that these crimes, that these pieces of legislation were made and built to prevent the reoccurrence of, have suddenly disappeared from the face of Trinidad and Tobago. The next one is a piece of legislation that they brought called the Anti-Gang Act 2011, and then they had various bail amendments. Madam Speaker, citizens of Trinidad and Tobago, through you, these pieces of legislation are to continue the sunset provision until August 2018, dealing directly with the crimes of kidnapping, firearm-related offenses, and anti-gang offenses in particular. These three very important pieces of legislation, and we shall come to, very respectfully in a short while, Madam Speaker, the evidence of none other than the Acting Commissioner of Police and what he has said in sworn testimony about the need for the continuation of this legislation. So you have the Commissioner of Police, the Acting Commissioner of Police, who is head of the major law enforcement arm in Trinidad and Tobago, going before the courts and saying in sworn testimony, this legislation should continue. So I put frontally here today, Madam Speaker, that the opposition would have to tell Trinidad and Tobago, when we go to vote today in a few hours' time, why it is that they would once again, in the face of a plea and a cry from the law enforcement agencies, they would or would not support this legislation. And we ask, please be a responsible opposition. Let us put aside the politicizing of crime and matters that are done to fight crime, and let us do what is right for the citizens of Trinidad and Tobago. And I'd like to use that opportunity, Madam Speaker, to start, because we heard a short while ago quite a lot of interesting quotation of Hansard and other matters. I'd like to start by quoting from one of the cases that the Honourable Leader of the Opposition referred to. That is a case of Ryan Reno Mahabir versus the Attorney General of Trinidad and Tobago, CV 2015-03229. And in this case, which was decided by the Honourable Madam Justice Gobin, which is actually the subject of an appeal, which was the simple point being made by the Attorney General, it is interesting that for the claimant, it is none other than an Anand Ramlogan who led the team against challenging these provisions that he implemented as law whilst he was the Attorney General. And I quote from paragraph 16 of the case and the decision of the Honourable Madam Justice Gobin. He contended, meaning Anand Ramlogan, that what could be gleaned from it was that there had been regular oversight by Parliament on bail legislation generally. The number of amendments between 2001 and 2015 evinced a responsiveness to the changing social environment and the worsening crime situation. There was a discernible trend. Parliament had been steadily expanding the categories of cases in which persons would be ineligible for bail. In the circumstances, he, that is Anand Ramlogan, appealed for judicial restraint. Any interference which frustrated the express intention of Parliament to continue the trend could amount to judicial legislation. So you have the former Attorney General, who was the main mover of many of these pieces of legislation when they first came to the House, saying that this is necessary and is responsive to a changing social environment, that being the unfortunate social environment and expansion of crime and criminality against the innocent citizens of Trinidad and Tobago. I also found it interesting, Madam Speaker, that in the Senate on Tuesday, the 1st of March 2011, in a contribution to do with the Miscellaneous Provisions Kidnapping and Bail Act 9 of 2011, the then Attorney General, Anand Ramlogan, said the following: "But in any event, we feel fairly confident that this is a measure that will bring some relief, and we intend to err on the side of protecting the rights of the victim and those who are involved in kidnapping. 120 days denial of bail, as far as this side is concerned, having regard to the gravity of the offence and the circumstances and the attendant multiple offences which are committed, including rape while the person is abducted, we do not think that 120 days denial of bail in these circumstances is something that is too harsh at all." So the question becomes, what has changed? What has changed between having that position and now? He went on to say, the then Attorney General, for those on the other side, he went on to say, "We expect that this law will benefit the large majority of citizens, and we feel confident that the judiciary is independent and fair in this country and will be able, under its inherent jurisdiction, in an appropriate case, to do justice to the defendant as it sees fit." So again, that was the position being elucidated at the time by the Attorney General when he was passing these pieces of legislation originally. We then fast forward to Friday, December 6, 2014, and the Bail Amendment Act number 1 of 2014, Again, the then Attorney General Anand Ramlogan, stating to the House of Representatives on this occasion, but significantly, Part 4 of our Constitution in Chapter 1 gives Parliament the authority to pass laws which are inconsistent with those fundamental rights with a 3/5 majority, provided that those laws are reasonably justifiable in a society with proper respect for the rights and freedoms of individuals. The respect for rights of freedoms of individuals, the rights and freedoms of those, and the freedoms that we must respect, because we must be viewed from two perspectives. The first is the right to respect the freedom of law-abiding citizens, and then to respect those who find themselves on the wrong side of the law and would be entitled to a fair trial. And I commend these words, Madam Speaker. Unfortunately, I must commend them. For some time now, we've seen the lawless elements encroached further and further and pull the rug out from beneath the feet of the innocent, law-abiding citizens in our country. Parliament has been slow to react, and we have been very unresponsive to the cries and the frustration and the desperation that has set into our population as a tiny handful of minority criminal elements in our society take root, grow, and take hold of our communities. Madam Speaker, the question that must be answered by those on the other side respectfully this afternoon, to the population of Trinidad and Tobago, and not to those who sit on this side in government now, is what has changed. What has happened now with respect to the fight against crime and to providing law enforcement agencies with a necessary tool, according to them, as I'll come to in a short while, in a tool in the fight against crime? What has changed? What has changed for those on the other side, that they can look at the population and face them in their eyes and tell them there's no longer a need to deny an immediate, because it is only the denial of an immediate right to bail for those who are found in possession of illegal firearms. And we will come to the statistics in a short while, where we have none other than the Acting Commissioner of Police saying, actually, well, let's go there immediately. Let me tell you where it comes from. Let me tell you where it comes from. Madam Speaker, for the population at large, through you, parliamentarians have something called caucus. There's a caucus on the side of the opposition, there's a caucus on the side of government. Caucus means those who are charged with the responsibility and the privilege of representing at a representative level, being an elected member of parliament, and those who are appointed by either the leader of the opposition, the Honorable Prime Minister, or the President in the Senate, get together, huddle, and discuss how we're going to approach the issues of legislation in the parliamentary houses of the Senate or the House of Representatives. And I'd like to put on record here today, Madam Speaker, it is the responsibility of every single member of caucus, when you get together with your respective parties to discuss legislation that is on the agenda, to contribute, to put forward to your fellow members of your caucus any salient facts that you may know, anything that you have in your domain of knowledge. That is how responsible parliamentarians should behave. So I've heard the cries. I've heard the cries from the opposition, and I hear it continuing for Oropuch East, asking for statistics to be provided. That is very, very misguided, Madam Speaker. And I'd like to put on record here today that the statistics that I was provided with last night actually have been residing in the bosom of the opposition since May 2016. And I tell the population how it is. Those on the other side were in possession of these statistics that we only got last night. It is a case that is currently before the court being led by Anand Ramlogan and one acting Senator, Gerald Ramdeen. So Acting Senator Gerald Ramdeen, who attended this week in discussions with the government, has obviously hid, because I can't believe that anyone on the other side would have had access to this and then tell the population they don't have access to the statistics to do with the crimes of to do with the repeat offenses, to do with firearm-related crimes and gang-related crimes. This has been in the possession of those attorneys at law since May 17th, 2016, and are, for the record, Madam Speaker, public documents. So we have had it confirmed now that in that case, you have junior counsel, who is part of the caucus of the other side, having these documents in his possession. And I'd like, through you, and with your leave, Madam Speaker, to refer to the evidence that has been provided by the Commissioner of Police. And this is what the Commissioner of Police is provided to the court in sworn testimony, but in this instance, provided to attorneys on the other side, including Senator Gerald Ramdeen, who is part of the caucus and who attended as part of the opposition's membership with the Attorney General this week. He's here today. He was here today, as usual, fled from the chamber. Fled from the scene. And this is what was said. This is what is on record as having been said, Madam Speaker.
Member for Caroline, I'm on my legs. Member for Diego Martin West, can you continue, please?
Thank you very much, Madam Speaker. So, Madam Speaker, the population of Trinidad and Tobago should know that this was in the possession of the other side for over 6 weeks and is now being told to them. The Acting Commissioner of Police says there are currently 6,810 police officers enlisted in the police service. As of March 1st, 2016, that is a period in time when we are in government on this side and we are doing what we can to deal with the crime situation. The Commissioner of Police says, as of March 1st, 2016, the Cabinet of the Republic of Trinidad and Tobago approved an increase in the sanctioned strength of the police service by 168 officers. They asked for more police officers. We gave them more police officers. The Commissioner of Police goes on to talk about the interconnected nature of the drug trade and the importation of illegal firearms. Madam Speaker, this is the information that the public of Trinidad and Tobago needs to know about, and why we now come to this Parliament to ask for an extension of time for us to put the House in order during our increased sunset provision, and what it is that the law enforcement authorities are asking for the continuation of these pieces of legislation to fight crime. Trinidad and Tobago, if you would wait, you will get everything. If you ask Mr. Ramdeen, you will get it even quicker. Trinidad and Tobago, due to its proximity to South America and its location as the southernmost island of the Caribbean archipelago, serves as an ideal transshipment point for the movement of large quantities of dangerous drugs from the world's chief source of cocaine and its primary consumer market, the United States of America and Europe. The illicit trade in narcotics has contributed in no small measure to the high level of criminal activity within the country. It is one of the main drivers of the commission of serious violent crimes such as murders, kidnappings, shootings, and woundings with rival gang leaders. The point I'm making, Madam Speaker, is this goes centrally to gang, anti-gang legislation, illegal firearm possession, fighting narcotics, and trafficking in persons. He goes on to say there's a direct linkage between the importation of illegal firearms and narcotics. Illicit firearms frequently accompany shipments of narcotics into the country. The challenge, however, is that whilst most shipments of dangerous drugs stay very briefly within our borders, firearms and high-powered weapons which enter alongside them remain long after the narcotics have left our shores. Illicit firearms which arrive with drug shipments enter into circulation locally and are traded among criminal elements as a tool to support drug operatives, human trafficking, the commissioning of robberies, kidnappings, and murders fueled by drug deals gone awry, and in strengthening the armory of existing gangs in their turf wars and their perpetuation of criminal activity. Statistics compiled by the CAP show that for the years 2004 to 2015, the number of illegal firearms seized by the police service has been increasing steadily, with the exception of 2010 and 2012, which recorded minor decreases. By way of example, 691 firearms were seized in 2015 as compared to 112 seized in 2004. an increase of over 500%. The 691 firearms seized in 2015 represents the highest number of weapons found and seized in the history of the police service. Despite a general increase in the number of firearms seized per annum, firearms, and Madam Speaker, this is important, and I'd like to highlight what the Commissioner of Police is saying here. Despite a general increase in the number of firearms seized per annum, firearms continue to account for rising levels of violent crime in society. Firearms remain the predominant choice of weapon used in the commission of murders and other violent offenses such as wounding, shooting, and robberies. For example, in 2009, there were 507 murders, of which 364 were committed with the use of a firearm. This represented a total of 71.4% of all murders. In 2013, firearms accounted for 78.4% of all murders committed in Trinidad and Tobago. So the point being made here effectively with the use of statistics, Madam Speaker, is that the prevalence of firearms and illegal firearms and the possession of illegal firearms is one of the major scourges of crime, and the assaults that have to be, and the assaults on the citizens of Trinidad and Tobago, and it is something that the police service is making its best efforts to attempt to circumvent. But the police service, as I will come to in a short while, through the Commissioner of Police, are telling us we need the continuation of these provisions with respect to no bail for those found in illegal possession, with illegal possession of firearms, to allow us a period of time to keep repeat offenders off of the streets. And I make the point at this stage that it is not that they denied bail completely. In 120 days, if the police service or the DPP's department, whoever is charged with the responsibility of prosecuting these crimes related to the illegal possession of firearms and other criminal matters, don't bring their case to court in 120 days, those who have been accused and charged can apply to the magistrate in the first instance and then to a high court judge in the second instance for bail. So what the police service are asking for is 120 days to deal with repeat offenders who are found in possession of illegal firearms. And there are the statistics here to support that the vast majority of those who are found in possession of illegal firearms, it is a repeat offense. They're constantly being held by the police service with illegal firearms. The Acting Commissioner of Police says the possession of firearms and the commission of violent offenses with the use of firearms presents the greatest challenge to policing in Trinidad and Tobago and to the maintenance of law and order. That is worth repeating. The Commissioner of Police, the Acting Commissioner of Police, has said in sworn testimony that possession of firearms and the commission of violent offenses with the use of firearms, and of course these are illegal firearms, presents the greatest challenge to policing in Trinidad and Tobago and to the maintenance of law and order. Firearm-related violence is the most critical factor which influences the public perception of crime and the fear of crime. The police service's #1 priority for 2016 is the reduction of firearm-related violence, particularly shootings, woundings, and murders. It is envisaged that this will be achieved through the strengthening of key specialist units, including the CGIU and the OCNFB, along with greater monitoring of points of entry. Challenges proposed by development of gangs, and he gives evidence with respect to gangs and the challenges they're facing. And he says the use of illegal firearms and specifically high-powered weapons are particularly prevalent amongst gang members. In addition, the increased number of gangs and gang-related activity in the country has fueled an increase for the demand of illegal firearms and sophisticated weapons. The Commissioner of Police then goes on to talk about repeat offenders. Many persons charged with criminal offenses re-offend while on bail. This is the evidence that the country needs to know and what we're asking the opposition to take note of. None other than the Acting Commissioner of Police. Many persons charged with criminal offenses re-offend while on bail, and those with previous convictions often continue to lead a life of criminal activity. A more acute threat is posed by those who are gang members in that their access to organized networks and financial resources, high-powered weapons, access to trans-border criminal networks and narcotics facilitate and perpetuate future criminal activity. In many instances, criminal activity is targeted against persons, and this is an important point, and the Honourable Member for St. Augustine would be aware of this because of the type of practice. One of the reasons to try and keep people off of bail or out of bail is that they found, and the police are giving evidence, that the continuation, that to allow these repeat offences back out, they often threaten witnesses. So the Commissioner of Police is saying, in many instances, criminal activity is targeted against persons who are suspected to be informants to the police, victims who have come forward and reported offences to the police, witnesses who are assisting the police in their investigations, investigating officers within the police service, and also prison officers, Madam Speaker. Continued criminal activity therefore threatens to completely undermine successful prosecutions and to subvert the entire criminal justice system. He concludes, respectfully, Madam Speaker, and this is the plea. There is a clear link between the importation and distribution of drugs and firearms and the need for gangs to protect these activities. Furthermore, this has engendered an increase in firearm-related murders. One major initiative in reducing all of these activities is to monitor the persons who are involved in them. This upsurge in crime has resulted in a trend to increase the manpower requirements. Furthermore, the restrictions on bail contained in several acts of Parliament between 1994 and 2015 is just one limb of a multifaceted strategy to reduce the incidence of violent strategy crimes. So the Commissioner of Police is on record saying in sworn testimony that this upsurge in crime has resulted in the need to increase manpower requirements, and furthermore, the restrictions on bail contained in several acts of Parliament between 1994 and 2015 is just one limb of a multifaceted strategy to reduce the incidence of violent crimes committed against society. So, Madam Speaker, those are the statistics. Those are the pleas via sworn testimony of the Acting Commissioner of Police as to why this legislation should continue. He goes on to file a supplemental affidavit, again which should be in the possession of those opposite, and says, according to the records held by the Criminal Records Office, of the 793 persons who committed firearm-related offences in 2014, 304 persons, or 38.3%, had been previously charged with or convicted of a previous firearm-related or violent offence. Of those 304 persons, 110 persons had one previous conviction or pending charges, 50 persons had two previous convictions or pending charges, 119 persons had 3 or more previous convictions or pending charges. So, Madam Speaker, we do not stand here on this side and speak lightly. We do not stand here on this side and speak without the support of statistics. We stand here on this side and make a plea as advocates on behalf of the citizens of Trinidad and Tobago to those on the other side to continue the support for an extension of time for this legislation. This is a plea for the citizens of Trinidad and Tobago to those on the other side to support this legislation to provide the law enforcement agencies who are pleading for a continuation of this legislation in their fight against crime. Take the politics out of the fight against crime. Let us do what is right for the citizens of Trinidad and Tobago. And he goes on to say, in 2015, there was a slight reduction in the number of persons committing firearm-related offences. Of the 720 persons who committed firearm-related offences, 250 of these, 34.7, had been previously charged with and convicted. The statistics up to May 10, 2016 are that 222 persons have committed firearm-related offences. 84 of these, or 37.8%, have previously been convicted of or charged with firearm-related offences. Of this 84, 27 have had one previous. Madam Speaker, the statistics show, without fear of contradiction, the prevalence of repeat offenders, the prevalence of this criminal element in society using illegal firearms to perpetrate the worst types of criminality on the innocent citizens of Trinidad and Tobago. And it is with this contextual background and setting the Attorney General has led the charge here in this House for continuation of the existing state of bail, of the existing state of the bail legislation to be continued to allow the law enforcement. The Leader of the Opposition was correct. Sunset clauses are inserted into legislation to allow the authorities a period of time to try and put their house in order. But what we have here, Madam Speaker, respectfully, is the most compelling plea of none other than the head of the Police Service of Trinidad and Tobago, asking us as parliamentarians to continue with these bail provisions. And he says, as the statistics have shown, there are persistent reoffenders who pose a significant threat to the administration of the criminal justice system in Trinidad and Tobago and to public safety. It appears that there is little which deters these persons from engaging in continued criminal activity. These are the words of the Acting Commissioner of Police. There remains a challenge of finding...
Member for Port of Spain North, St. Anne's West, your 30 minutes have expired. I would like to suggest now that we take the suspension and we return at 4:55.
Follow the Parliament of Trinidad and Tobago on Twitter. Our call sign is @TTParliament. This is the Parliament Channel and Parliament Radio 105.5 FM.